Tonight we're live in Washington, D.C., where the Supreme Court debates a fundamental right at the heart of American democracy. The Wolford case challenges state bans on large-capacity magazines, a legal and cultural showdown with global implications. The core question: where does public safety end and the right to bear arms begin? The justice's decision will reshape gun laws nationwide and set a precedent for generations. We'll break down the history, the arguments, and what's at stake for America and beyond. This is more than news, it's a pivotal chapter in the ongoing American experiment. To truly understand the significance of the Wolford case, we need to take a step back and explore the long and complex history of magazine bans in the United States. The story of these laws is not just about legal battles, it's about shifting public attitudes, political movements, and the ongoing struggle to balance public safety with constitutional rights. One of the most pivotal moments came in 1994, when President Bill Clinton signed the federal assault weapons ban into law. This legislation, which lasted for a decade before expiring in 2004, was the first major federal effort to restrict the sale and possession of certain semi-automatic firearms and magazines holding more than 10 rounds. The law sparked fierce debate in Congress and across the country, with supporters arguing it would reduce mass shootings and opponents claiming it infringed on the rights of responsible gun owners. Although the federal ban eventually lapsed, it set a powerful precedent and opened the door for states to take action on their own. In the years since, the landscape has changed dramatically. Today, about a dozen states, along with Washington, D.C., have enacted their own laws restricting magazine capacity, typically limiting magazines to 10 or 15 rounds. These laws vary widely in their details and enforcement, reflecting the diverse attitudes toward gun ownership and regulation across the country. Some states have even faced legal challenges and ballot initiatives as residents and lawmakers continue to debate the best path forward. Supporters of magazine bans argue that these laws are a crucial tool for saving lives. They point out that forcing shooters to reload more frequently can create critical moments for victims to escape or for law enforcement to intervene. High-profile mass shootings have often reignited calls for stricter magazine limits, with advocates emphasizing the potential to reduce the number of casualties in such tragic events. On the other side, opponents of magazine bans see these laws as a direct threat to the Second Amendment. They argue that most standard magazines for popular firearms hold more than 10 rounds, and that restricting access to them unfairly penalizes law-abiding citizens while doing little to deter criminals. For many, the issue is not just about self-defense, but about preserving fundamental freedoms and resisting what they see as government overreach. The debate over magazine bans is deeply personal and often emotional. It's shaped by stories of survival and loss, by fears of violence and hopes for safety, and by deeply held beliefs about self-reliance and constitutional rights. Across the country, families, communities, and lawmakers continue to wrestle with these questions, searching for solutions that honor both public safety and individual liberty. Now, with the Wolford case arriving at the Supreme Court, decades of political, legal, and cultural conflict are coming to a head. The outcome could reshape the future of gun laws in America, and the nation is watching closely. The modern legal landscape of the Second Amendment truly began to take shape in 2008. With the landmark Supreme Court case District of Columbia versus Heller. Before Heller, the meaning and scope of the Second Amendment were hotly debated, with many courts and legal scholars uncertain whether it protected an individual right or merely a collective one tied to militia service. The Heller decision changed that conversation forever. In a 5-4 decision, the Supreme Court affirmed that the Second Amendment guarantees an individual's right to possess firearms, particularly for self-defense within the home. This was a monumental shift, as it recognized that law-abiding citizens have a fundamental right to keep and bear arms, not just as part of a militia, but as individuals seeking to protect themselves and their families. The ruling sparked celebrations among gun rights advocates and ignited new debates about the limits of this right. However, Heller was not an unlimited endorsement of gun ownership. The court made it clear that the right to bear arms is not absolute. It allowed for certain long-standing prohibitions and regulations, such as restrictions on firearm possession by felons or the mentally ill, and bans on carrying firearms in sensitive places. Importantly, Heller introduced the common use test, suggesting that only weapons commonly used by law-abiding citizens for lawful purposes are protected. In the years following Heller, lower courts developed a two-step framework to evaluate gun laws. First, they asked whether a regulation burdened conduct protected by the Second Amendment. If it did, they then balanced the government's interest in public safety against the individual's right to bear arms. This approach often led courts to uphold various gun control measures, including bans on high-capacity magazines, arguing that such regulations served important public safety goals. But in 2022, the Supreme Court dramatically altered the legal landscape once again, with New York State Rifle and Pistol Association versus Bruin. This case challenged New York's strict requirements for carrying handguns in public, and the court's decision sent shockwaves through the legal community. The Bruin decision rejected the two-step balancing test that lower courts had relied on for years. Instead, the court declared that any gun regulation must be consistent with the nation's historical tradition of firearm regulation. In other words, if a modern law lacks a clear historical analog from the time of the founding or early republic, it is likely unconstitutional. Now, only those regulations that can be firmly rooted in American history and tradition are considered constitutional. This new standard has made it much harder for governments to justify modern gun control measures that lack direct historical precedent. As a result, laws banning high-capacity magazines, which were often upheld under the old framework, are now in legal jeopardy. This dramatic shift in constitutional interpretation is what brought the Wolford case to the Supreme Court's doorstep, as justices are now asked to decide whether such bans can survive under the new historical test. The central question before the court is this: are modern magazine bans truly consistent with the historical understanding of the right to bear arms, as envisioned by the founders? The answer will have profound implications for gun laws across the nation. In 2022, the state of Washington enacted a controversial law banning the sale, manufacture, and distribution of firearm magazines capable of holding more than 10 rounds. This move sparked immediate backlash and set the stage for a legal battle that would soon capture national attention. The case at the heart of this storm is Wolford versus State of Washington, a lawsuit that quickly rose through the courts due to its potential to reshape gun rights law across the country. The plaintiffs, led by Mark Wolford, a longtime gun owner and advocate, challenged the law on constitutional grounds. They argued that the ban directly violates the Second Amendment, especially in light of the Supreme Court's 2022 Bruin decision, which emphasized that gun regulations must align with the nation's historical tradition. Wolford and his legal team pointed out that millions of Americans legally own magazines with capacities greater than 10 rounds for self-defense, sport shooting, and other lawful purposes. They contended that the state's restriction targets common, widely used firearm components, not rare or unusually dangerous items. Central to their argument is the claim that there is no historical tradition in the United States of banning firearm magazines based on their capacity. The plaintiffs' legal briefs highlighted that for over 2 centuries, Americans have had access to firearms and their components without arbitrary limits on magazine size. They argued that the state's law is a modern invention, unsupported by the historical record. On the other side, Washington state's attorneys countered that magazines are not arms, protected by the Second Amendment, but rather accessories that can be regulated. They argued that the state has a responsibility to protect public safety by restricting items that can increase the lethality of mass shootings. According to the state, regulating unusually dangerous accessories is consistent with historical precedent, and the law is a reasonable response to modern threats. To support their case, the state cited historical laws that regulated dangerous weapons and the storage of gunpowder in densely populated areas. They argued that these old regulations serve as analogs for today's magazine capacity limits, showing that governments have long had the authority to address new threats as technology evolves. As the case made its way through the courts, lower court judges issued conflicting rulings. Some upheld the ban, while others struck it down, leading to a split among federal circuit courts. This division created legal uncertainty not just in Washington, but across the country, as similar laws exist in several other states. Recognizing the national significance of the issue and the need for a uniform standard, the Supreme Court agreed to hear Wolford versus State of Washington. The justices' decision to take up the case set the stage for a high-stakes showdown, with arguments scheduled for this week. Legal experts, advocacy groups, and citizens on both sides of the debate are watching closely, aware that the outcome could have far-reaching consequences. The Supreme Court's ruling could finally resolve years of legal uncertainty, providing clarity on the limits of state power to regulate firearms and their components. For millions of Americans, the decision will shape the future of gun rights and public safety for years to come. On January 27, 2026, the Supreme Court heard Wolford's oral arguments in a tense, packed chamber. Paul Clement argued for the challengers, emphasizing that hundreds of millions of these magazines are in common use and thus protected. Washington's Noah Purcell countered that the focus should be on the magazine's dangerous characteristics, not just their numbers. He likened the ban to historical regulations on hazardous weapons and storage. Justices pressed both sides on how to apply 18th-century legal principles to modern firearms. The debate revealed the challenge of bridging history and present-day technology. The outcome remains uncertain, with justices probing for a workable standard. The justices' questions revealed deep divisions. Chief Justice Roberts sought a limiting principle, asking if any magazine, no matter how large, could be protected if common enough. Justice Thomas pressed for historical evidence of capacity-based bans. Liberal justices, like Kagan, questioned whether the Second Amendment should adapt to modern threats. Justice Gorsuch explored whether magazines are integral to firearms or mere accessories. The bench's probing highlighted the difficulty of applying historical tests to today's weapons. The final decision is unpredictable, with the court split on both principle and precedent. A decision is expected by June 2026, with immediate national impact. Striking down the ban would invalidate similar laws in a dozen states, energizing gun rights advocates and reshaping the firearms market. It could also deepen political divides and force law enforcement to adapt. Upholding the ban would clarify Bruin's limits, empower states to regulate, and frustrate gun rights supporters. Either outcome will spark new legal and political battles. The ruling will define the Second Amendment's reach for years to come. The stakes are enormous for law, politics, and public safety. Wolford will not end the debate, but it will redraw the lines. Legal experts see Wolford as a test of the Bruin framework's limits. Some, like Professor David French, note the challenge of finding clear historical analogs for modern magazines. Chief Justice Roberts may seek a narrow ruling to avoid extreme outcomes. Gun control advocates argue the Second Amendment allows regulation of new, dangerous threats. Critics say the Bruin test forces debates into history, ignoring today's realities. Most agree the case is too close to call and will hinge on one or two swing justices. The future of gun control and the Second Amendment hangs in the balance. As the justices deliberate, America stands at a constitutional crossroads. Wolford v. Washington crystallizes the clash between gun rights and public safety. The ruling will ripple across law, politics, and society, shaping the Second Amendment for a generation. The stakes are immense, and the weight is tense. This decision won't end the debate, but it will set the terms for what comes next. Understanding the principles at stake is essential for every citizen. For now, the nation, and the world, waits for the Supreme Court's answer.